Hi there, everyone. I'm Annette Fisher. I'm the founder of PESID, and I'm here today with Anthony Minko. Anthony is an estate planning and elder law attorney, and he is going to tell us a little bit about himself.
Hello, everyone. Good afternoon. Hope everyone's doing great out there, enjoying this late summer, early fall weather. So I'm an estate planning and elder law attorney here in Brooklyn, New York. I focus on wills, trusts, asset protection, Medicaid applications, also estate tax planning. I help a lot of clients with their business planning needs, LLCs, corporations, etc. So our practice is focused on those areas. And today I'm happy to be here with you, Annette, to talk about some of the top 10 must answer questions.
Yes, thank you, Anthony. So, the first thing we're wondering about, I run across this a lot of times, is that people all of a sudden have a catastrophic situation and they go to a hospital maybe, and perhaps they've broken a hip or a pelvis or something to that effect. Now
Mhm.
they have to go for rehab. And sometimes they can't go back home right away from rehab. So I'm wondering, how does that work out if they have to get some kind of assistance? Like, are they going to lose their money and what they own and all?
Sure. Well, as you know, everyone has Medicare once they reach the age of 65, and or they could have a Medicare Advantage plan. But most of the Medicare or Medicare Advantage plans, they only cover a limited amount of rehabilitation in a nursing home or rehab facility, and the maximum amount that they cover is typically 100 days per incident or occurrence. So if someone needs to be in that rehab for more than the 100-day coverage period through their regular insurance, then they might have to pay out of pocket. Now, the 100-day coverage through Medicare for rehabilitation is the maximum. It is possible for the facility to say that the individual patient is no longer making improvements, and then say that they are only going to qualify for 20 days, 30 days, 60 days of rehabilitation coverage through Medicare. So the risk is that if a client or individual needs to be in that facility for more than the 3 months or so that's covered, they have to pay for it out of pocket.
Hmm.
Now, if they have money in the bank, they're not going to be eligible for any Medicaid benefits because under the Medicaid rules, the law says, hey, use your money to pay for your own care first. Now, let's say if they own a home that they live in, and it's their primary residence, they may be eligible for Medicaid benefits initially while they're alive, but technically, when they pass away, Medicaid could assert a lien against the property. They may even assert that lien at the time that the application is submitted, before the person dies, or they could do it after or in the probate court. So even the primary residence is at risk if that individual person has to remain in a nursing home.
Hmm. And I know your background is to be the attorney. However, would you know on the insurance side, just because, let's say, insurance might give them 20 to 100 days of coverage, is that automatic, or do they have to have certain requirements to be able for that coverage to actually work in a nursing home?
Yes. So essentially, the coverage is there if the person is rehabilitating, if they're making steady improvements. So let's say if someone falls and they break a hip or they break some bone, they're in the hospital for a certain amount of time, they have surgery, then they go to rehab. Now they could be in that rehab for a full 100 days, and during that 100-day period, be making consistent improvements, going to therapy, learning to, walking, pushing themselves, taking the stairs again, transferring, getting in and out of bed, in and out of a chair, learning all those basic skills. Now, if after 30 or 40 days, the person stops getting better, maybe they stop going to the physical therapy, and then they're not making any more improvements, and especially if they're just remaining in bed, at that point, the facility can classify through their social workers and the evaluations that they do and those assessments, they can classify this person as a long-term care patient, that they're not there for a short amount of time for short-term rehabilitation to get better and then go home, that they are there for long-term custodial care, that they're not going to be headed home. They're not making improvements. They're just there for custodial care.
So
Not
what's that mean? What's that mean? I'm sorry to interrupt you, Anthony. What's custodial care? People are probably wondering. I don't know what custodial care is.
Yeah, so custodial care means that you're just at the rehab because you can't be alone at home on your own. So you're not at the rehab because you need additional medical intervention to continue improving some type of medical issue. You're not going to get any better. You've plateaued at a given level of ability, and you're not able to be at home given the limited function that you have. So you just need someone to care for you. That means the care is custodial. You need to live with someone. Someone needs to live with you to care for you. Whereas if someone is there for rehabilitation, they're not there because they can never take care of themselves again. They're there because they had some medical incident, some surgery, some emergency, and now they're in the process of getting better. They're convalescing a little bit at a time. It might take 3 months, but they're getting a little bit better at a time. So that's the difference. And this is why we counsel clients that if your loved one is in that situation in the rehab, make sure, even if it's difficult, that they go to the physical therapy, that they show up, that they're not turning the therapist away for several days straight, that they're doing their best, being cooperative and trying to get consistently better. Then they're more likely to get the full 100 days of coverage. Now, if the person's not compliant, if they refuse therapy, and that happens for more than a few days, the facility may say at any given point, hey, this person's not rehabilitating anymore. They're just there to stay. They're just here to stay here. We're not going to have Medicare coverage. So the whole thing is that when that Medicare coverage runs out, you either pay the private pay rate if you need to stay there, or you have Medicaid pay, or you go home. Now, they still can't discharge you unless it's a safe environment at home. But what we're trying to do is protect those assets in advance. So if someone owns a home, if they have money in the bank, different investments, annuities, stocks, bonds, whatever, insurance, get those assets out of their name in advance to prepare just in case they need some type of care. Now, all of a sudden, they would be eligible. Okay, so it's really the pre-need planning is what we call it. Pre-need, before they need it, is the ideal.
Okay, so Anthony, how would their assets be affected by something like this? Like, let's say they didn't do any prior planning. Is there anything they can do at the last minute, maybe, to protect stuff?
Mm-hmm. Yes, so it depends a little on the circumstances and whether they own real estate or it's cash in the bank or it's retirement accounts. So every single asset is handled a little bit differently in terms of if it's in the person's name and they need care. Unfortunately, we live in one of the most expensive markets in the country when it comes to nursing home care. So it's often $600 per day, $650 per day, which is $20,000 or so per month in the rehab. So the consequence of not planning is, and it's maybe a 10 or 15% chance around the country that someone over the age of 65 will require some type of inpatient facility long term. So let's say it's a 10 or 15% chance. Most folks aren't going to need a nursing home long term. But if that happens, if you're one of the unlucky ones, it could be $200,000, $250,000 a year. So let's say you own a home, you're in the nursing home for 2 years, before someone passes away, Medicaid will have a lien on the property for $500,000. So after the person's gone, the beneficiaries, the children go to sell the house, they have to pay back the money that was spent on nursing home bills. So the consequence is that your life savings are at risk unless there's some type of plan to protect them, because of the fact that regular insurance just doesn't pay for all the things that might be required.
Okay. So if someone were in the hospital and or nursing home and they became not just that they needed rehab, but they became incapacitated,
Mhm.
how would their family manage to get to like their assets and deal with things like what should already be in place, hopefully? What
Hmm.
if those things aren't in place? Then what?
Okay. So essentially, there's a legal document that's very important in the event of incapacity, and that's called a power of attorney. So, a power of attorney is a specific document that allows a friend or a family member, whoever you designate as your agent, to make the legal decisions on your behalf. And so, if you're not able to make decisions on your behalf, if your loved one has that power of attorney, they can then go to the bank for you, call the insurance company for you, call deal with whatever legal issues, financial issues, tax issues might be there on your behalf without you having to be on the phone. Now, that power of attorney needs to be signed, obviously, while the person has capacity. So it has to be done in advance. So if someone suddenly loses their capacity, let's say sudden hospitalization, and now they're not able to manage their own affairs, if they don't have a power of attorney, it's too late for them to sign one because they're not able to do so. So what happens under those circumstances, we go through what's called a guardianship proceeding, where we need to go to the surrogates court or to a Supreme Court and say this particular individual can no longer manage their own affairs, and this person in their family or friend or whomever interested party it might be is now applying to be their guardian. So in other words, mom or dad's bank accounts might be frozen if they're in the hospital and can't call the bank, and their children, their niece, nephew, whomever is going to manage it, won't be able to access that money on their behalf unless their name's on the account. If their name's not on the account and they don't have a power of attorney, we have to go to court to get access to the money. Now, that guardianship proceeding can take a very long time here in New York City. It can be very expensive. And it's the last thing really the family wants to do when the first priority should be to care for their, for mom or dad.
Could you touch a little bit on, Anthony, on like what a person has to go through once a guardianship is obtained in order to be able to conduct business on behalf of that person that they're the guardian for?
Yes, so this is a very good point. So even if the judge does appoint you as the guardian for a specific person, that does not give you carte blanche to spend that money, to use those resources however you see fit, right? So I just had a case earlier today where a woman has $50,000 in a guardianship account for her own daughter who's 14 years old. Now, the woman needs to use some of this money to pay for different expenses that her daughter has, including the dentist, other expenses that aren't covered. And before she can use the money from the guardianship account, she needs to get the judge's approval, right? And the judge might not approve her, most likely won't, because the judge is going to say, hey, you have enough money in your own name, so you need to use that money. Now, every case is different, but the point is that with a guardianship type of setup, the judge is still going to stay on to monitor that activity. And every year, the guardian will have to submit annual accountings to the court, specifying all the income, expenses, any changes in the account. So that's very cumbersome, especially if there's someone who you trust, who you can appoint as the agent.
Okay, so you talked a little bit about a power of attorney. What happens with the power of attorney after someone passes away?
So once someone dies, that power of attorney is no longer effective. So the power of attorney document allows the agent to transact business on behalf of the individual, but you're essentially standing in their shoes. But once that individual has died, the power of attorney is no longer valid. So what happens at that point is that we need to go through the probate court if there are assets in their name and proceed with an estate as opposed to keeping it in their name and accessing it via power of attorney.
Okay. So, what happens if a person has a lot of money in their account and they've got a house worth a lot of money, and now there's no will? And what happens? Like, who's going to pay these taxes and stuff? Like, what goes on there?
Mhm. So, in every county, there is someone known as the public administrator. So, this is essentially the executor of last resort. So, if someone doesn't have any documents and there's no family members that come forward to say, hey, this is my aunt, my uncle, my mom, or my dad, they died. I am their next of kin. I should inherit their assets. So, if someone dies without a will, if someone's in their family or an heir, some type of legal heir, they have the right to go to court to say, this individual died. I'm an interested party because I would be inheriting their money. So I'm going to stand in as their executor. Now, it's always better when the person appoints their own executor through their own will. If they don't do it through a will, it's called an administrator. So the administrator is someone who's appointed by the court to administer someone's estate, but the person didn't put it in their own will. The judge just appointed that person. And it's usually going to be an interested party. Now, there are cases where there's no close family members, no one appeals, and let's say if someone dies without any family, and there's no documentation, then ultimately the public administrator's office would administer the estate. And in rare cases where there are no heirs found, the assets can escheat to the estate, which means that the assets go to the government. But usually, even if there's no one to shows up to collect them, the public administrator has to do genealogical research, look at the birth records, try to track down a natural heir who would inherit those assets.
Okay. As part of dealing with an estate and what's the right order in which to do things, let's talk a little bit about if someone has a house.
Mm-hmm.
Kind of when's the best time to sell it when you're older? Let's say the person is very old and they're very sickly and they're expected to maybe pass away in a year. Is it better for the family to turn around and say, okay, let's just sell the property because we need the money and put them in a nursing home? Or is there a better method that you think should be used?
Well, this is an interesting question. I would say it's very fact specific. So every case, every circumstance is different, which is why it's important that every individual consult with an attorney who's qualified, who has the expertise necessary to advise them in their situation. But here's some of the general rules. When someone is selling a piece of real estate, let's say it's a home that they've lived in for many, many years. One of the questions we look at is how much money did they make on that investment? So what are their capital gains? So how much profit did they make on that house? So let's say you bought the house for $100,000, many, many years ago, and now it's worth $1 million, right? Well, simple math, you paid 100 and now it's worth $1 million, right? What's the gain there? How much profit is there? There's $900,000 of profit. Okay. Now, how do you calculate those taxes? It's a little complicated. There are different exemptions. It matters how long you've lived there, how much money you've put into the property, etc. But what happens under the tax law is that when someone dies at the time of death, the IRS basically resets all those capital gains. So if the house is worth $1 million when mom and dad pass away and then they die, the IRS counts it at $1 million for the benefit of the kids. So when the parents are alive, it counts at that 100,000. And if they sell, they would have all the gains. But at the moment that they die, the IRS erases those gains and they start at the high point. So when the kids inherit that house at the time of death, they inherit it at the million. They sell it for $1 million. They pay no taxes. But if it's sold while the parents are alive, the parents still have that $900,000, all those gains to deal with. Now, again, they may or may not have enough exemptions to cover the sale. And oftentimes it varies depending on whether it's a primary residence or an investment property. So if someone owns, let's say, a 2-family home or 3-family that they don't live in, and it's an investment, they're not going to have as many of those exemptions to cover the capital gains. Whereas if they own a primary residence where they live, they will get more exemptions under the tax code. Okay. So one of the things that we look at, let's say, so in your example, Annette, if a loved one needs a nursing home and they own a house and they need money, if they sell the home while their parent is alive, there will still be capital gains on the property. If they sell it after the person dies, right, there will be no capital gains. So many times it does make sense from a tax point of view to wait until someone passes away to sell, because the capital gains may be better. But every situation is different. But when there are a lot of capital gains, one strategy we use in that, as you know, is a reverse mortgage. So if money is needed to pay for care, and if it seems like selling the house would result in a lot of taxes, instead of selling the house to raise the money, we just borrow against the house to raise the money. Use that reverse mortgage to borrow against the house, use the proceeds from the mortgage to pay the long-term care bills, and then when the person dies, sell the property. Avoid the capital gains because you sell after the time of death, and pay back the reverse mortgage. And in that case, you could avoid the capital gains taxes while still accessing the equity in the property without having to show all the traditional qualifications to get a typical mortgage, because a reverse mortgage, as you know, Annette, and your viewers know, works well for seniors.
So let me disclose here, since Anthony brought it up, I do work for Fort Funding. Fort Funding is licensed in New York, New Jersey, Connecticut, Pennsylvania, and Florida. You can find out more about Fort Funding at fortfunding.com/about. My NMLS number is 67606, and Fort Funding's NMLS number is 39463. Thanks for that little plug, Anthony. I wasn't expecting that. Okay. So what if someone sold the house and it was in an irrevocable trust? Is it those same rules apply whether it's in a trust or not in a trust?
If the trust is done properly, yes. So it depends on the circumstances, because some irrevocable trusts are essentially, they count as a gift. So this would be, let's say, a simple irrevocable trust where the client, let's say mom and dad, they don't retain any powers over the trust. They don't retain the right to income. They don't retain the right to change the beneficiaries if they're not serving as trustees. If it's an irrevocable trust where they have no authority, no ability to live in the property, and it's a completed gift, then the kids would have to pay the capital gains taxes. But most elder law attorneys are going to use what we might call an income-only trust or an incomplete grantor trust, where it is an irrevocable trust, but the client retains some power, some control. Because they retain a little bit of control, let's say they say, hey, I have the right to the income from that property. Even though I put it into the trust, if there's rent, I still want it to go to my name. Or maybe they say, I want to be able to change the beneficiaries. Even though the trust is irrevocable and I have it as my 3 kids, if my son doesn't give me a birthday card, I want to cut him out. So I want the right to change that trust or add someone else as a beneficiary. So those rights under the law, they actually help us in an irrevocable trust, because they mean that the IRS sees it as being owned a little bit still by the person, by grandma, by mom and dad, so that we avoid those capital gains. So really, it's a very complicated area of the law, and there actually were some recent IRS rulings on irrevocable grantor trusts that go right to this issue of whether the beneficiaries will have to pay capital gains or not. And the answer is really the trust has to be drafted properly to keep that same character, where at the time of death, the capital gains are reset. If it's not drafted properly, or if it's drafted, for a different purpose, then we might have to pay capital gains taxes. And I've had many cases over the years over the last 15 years in this practice area where folks have done planning the wrong way. And then let's say they sell this house for $1.5 million and grandma paid $200,000 for it. And they sell it after she died, but they received it in the wrong type of trust in the wrong way. And now they're paying $400,000 or $500,000 of taxes. So they're losing a third of their inheritance. Whereas if they'd done it right, they would lose zero. They'd pay zero tax. So this is one of the things about estate planning, which is that it's very important that you work with a professional with the right expertise in legal, financial, tax matters, as well as the elder care issues. Because if you're not aware of those issues, it could cost your beneficiaries substantially in the long run. You won't even know while you're here. It'll be too late by the time it happens.
Exactly. Thank you for that, Anthony. That's, I think, a big deal. And I think it's something that a lot of people don't understand. They go and maybe they've had, and I love my real estate attorneys that I know, but they'll go to a real estate attorney because they've dealt with them before. And they're like, can you do my will? Can you do my trust? And okay, maybe they could do a simple will. But when it comes to a trust, I always tell them, listen, you have to go to people who do this all the time because there's specific areas of law and you want to go to the specialists. And hence, that's why I have you on the show today.
And we have to say for compliance that, we don't use the word specialist in the law.
Okay.
Because that has a rare connotation, but we can say an expert. All right.
Okay.
Yeah. So I think, I am an expert in estate planning. And the one thing that happens a lot is that the client doesn't always know what they need. So many of my clients, come to see me and they say, Anthony, I just want to put the deed to my house under my children's names. And I have to explain to them why that simple deed transfer, from parent to child, from aunt to niece, why that simple deed change is very risky, why it's much better for them to do a trust, why the simple deed has tax problems. But some attorneys, if they don't have this expertise, and a client comes to them and says, hey, can you just do a deed for me to change the deed from my name to my kid's name? The client's not going saying, what's the best way to do it? They're saying, just do this for me, because that's what they think is necessary. And many times a lawyer just does what the client asks instead of digging deeper to say, what is the goal? What's the purpose? What are we trying to accomplish? Now, you might not know the best strategy to get there, but let's go through the goals and then let's go through the different legal options and figure out how to get there. So we don't want to put the cart before the horse. Well, we don't want to use that, the supermarket lawyering. A lot of people say, oh, I heard this at the supermarket. This is the kind of trust that I need. And then you go to the wrong lawyer and they'll say, oh, I gave you the trust you asked for. Well, why'd you ask for that? Because that was the supermarket recommendation.
Exactly. In the types of dealings that I have, and I'm also a real estate broker, I see a lot of people that change the deed and put it in the name of the children, and then they're missing that whole step-up basis that you just spoke about, because now that person received that home, way back when, maybe it's 10, 15, 20 years ago, when the house was worth 200,000 and now it's worth 2 million. And they've actually caused themselves a big consequence. So thank you for really going into all of that.
Yeah. And remember, they have to pay as to what the original purchase price was. So not what it was worth when it was given to them, but what it was worth way back when the person bought it initially. Okay?
Oh.
So
it is transfer the name to a new deed.
So let's say you transfer the name. It's not as of the date of the gift. It's as of the initial tax basis.
Wow, I didn't even know that. So that could have been $25,000 when they purchased it.
That's going to be the $25,000 in these cases. So, again, we're careful about those deeds, because we don't want to lead to this fiasco down the line.
Okay. And so as far as timeline is concerned, in someone's passing and the ability of the family to be able to access the funds, I think you said that a trust is a quicker method, right? But can that be delayed as well in any way? Can a trust be contested?
Yes. So, essentially, when someone dies, we have to look carefully at the title of each asset. So let's say if they have a bank account that's in their name and there's a beneficiary listed. That's very easy. We bring the death certificate to the bank gets the ID and a claim form from the beneficiary, and they pay out the money. Okay, if it's a joint bank account, the joint owner automatically owns it. Now, if someone dies and they own something in their own name with no beneficiary and it's not joint, then we have to go to the probate court. Because, let's say if it's a deed, a house is just in the person's name and they died, how do you transfer a deed? You sign on the bottom of the deed and you transfer it to the new owner. If you're dead, you're not supposed to sign anymore, okay? Now, this is Brooklyn, so sometimes dead people still sign, but that's not the right kind of lawyering. It costs more for that. Okay, that was just a joke, really. But no, someone dies, they can't sign. That's why we need the judge. The judge appoints their executor. That process in Brooklyn could take a year or more. Many times it's 9 months or more, because there's only two judges, two probate court judges for all of Brooklyn. They have to review all the wills, approve those wills. So that's why it's a year-long delay in many cases. Sometimes 6 months, sometimes 9 months. That's if it's not contested. Now, a trust, the asset is not still in the person's name when they die, right? The house, it doesn't say Mary Jones. It says the Mary Jones Trust is the owner. So even if Mary dies, the trust doesn't die. The trust lives on. It says Mary's in charge while she's alive or whomever. Then at the time of her death, this is automatically her backup trustee. Her daughter, her niece, her son, her friend, whomever is her backup. The trust specifies that. So it's an automatic succession immediately from initial trustee to the successor trustee, just like a beneficiary form. And that successor immediately takes over. Okay, so that's an immediate change. Now, it doesn't mean that the money goes to the beneficiaries. It's still in the trust name, but the trustee, the backup trustee, has title to now account for that money and distribute it. So now, whether it's through a will or a trust, before the executor or trustee distributes the money, they have to make sure all the bills are paid, the taxes are up to date, there's no debts. But yeah, typically with a trust, we're going to be distributing that money within a couple of months, the bulk of it at least, whereas with a probate, it might be a year or more. Now, if things are contested, which means that the beneficiaries or possible beneficiaries, maybe other heirs, want to fight over what the trust says or the will, then that goes through the court process and slows it down. With a will, it's a little bit easier to contest versus a trust. Also, with a will, you're already in a probate court proceeding. There's already a judicial proceeding with a judge that's moving forward. So if you're an heir who wants to contest, all you need to do legally is show up at some stage of that proceeding that's already ongoing. So that's why it's a little easier to contest a will with a probate, because the proceeding's already ongoing. With a trust, there is no judicial proceeding unless it's contested. So if you want to contest the trust, you have to start the proceeding on your own. You're not just showing up to a proceeding that's already going on. And you may not even have access to a copy of the trust. So if you're an heir who wasn't included in the trust is a private document between the trustee, beneficiaries, trustor, person who set it up. So it doesn't just go to everyone in the family. You might not even be entitled to a copy, never mind be able to contest it. So it's a longer process to contest a trust. It's not impossible, because after all, if something isn't correct or if it's done improperly, we want an aggrieved beneficiary to have the ability to contest something. So we always have the ability to contest it. But a trust, it's far more difficult. There's a higher standard. And also typically there's no legal proceeding that's ongoing. So that puts a higher burden on anyone who wants to contest it.
Okay, terrific. What if somebody has a will and they've now passed away, and the estate wants to sell the house and probate isn't finished.
Mm-hmm.
What is the proper procedure for that? What are the documents that, let's say, a real estate broker would need to be able to complete that transaction?
Yeah, so obviously, in order to go to closing, in order to close the sale and transfer the property finally, we need the probate, the letters testamentary at least, to have issued. So we need the will to be fully approved. We need the executor to have been appointed by the court before the transfer, before the closing of title can actually take place. But that doesn't mean that the property can't be listed on the market, or even that it can't be in contract. So this is where every agent should talk to their broker, because every situation is a little different on how much risk the broker wants to take. But we usually advise clients that you should not go to contract unless you know from the court that those letters are going to be issued soon. So, many cases we submit all the documents to the court and we're waiting and we follow up with the clerks and they say, hey, the judge is working on it. Guess what? Don't go to contract yet, because it could be another 6 months. But it might be on the market. If you file the probate proceeding and it's in the works, you might list it. But we want to be careful even with listing it. But sometimes we do, as long as we have some time frame. Now, once the clerk says, if we know the clerk and they say, hey, this is going to the judge, everything looks good, you got all the paperwork, should be signed in the next week or two, then maybe we're okay to go to contract. Because even between contract and closing, it could be a month or two, so or sometimes more. So we want to give a little flex time. So essentially, we can't go to closing till we get the letters testamentary, which is most of the probate work. In many cases, we might be able to go to contract, but we have to be pretty close to the finish line. Whether you list the property or not is really an individual decision. But if we think it's going to sell fast, we would say don't even list it until we know we're close to the end of getting those letters issued.
And I would think that the broker should disclose that in their listing, so that, otherwise they could really jam someone up and they'd probably be in for a lawsuit. So just to be clear for our viewers, the letter of testamentary, and I don't always get it out quite right, but that letter is what indicates who has been appointed as the administrator, and the administrator is the person who has the ability then to be able to sign documents on behalf of the estate, correct?
Yep, you got it. Yep. So that's it's a letters testamentary, and it's an executor when it's a will. Now, when someone dies without a will, it's letters of administration, and then it's an administrator. So if it's through a will, it's an executor and letters testamentary. With no will, it's an administration, letters of administration, and they're an administrator. But basically, they're the same exact role, and basically the same similar application through the court. But I've seen a lot of cases where people get aggressive. They say, yeah, this is my mom's house, I'm putting it on the market. They haven't even filed for probate. Now they're in contract and they want to sell it, and it's a year and a half, and they're in contract and lose the deal, or it's a nightmare. So tread carefully when you don't own the house yet.
I've come across some real estate agents that don't get it, and they're taking listings, and I'm like, what do you mean you didn't have any letters? And they're like, what letters? What's a letter? A letter from who? And so it's kind of scary. So good information you're giving out here.
And one thing about our office is, we try to give as much information out as possible. If you call our office, speak with our office manager, give her some details of what's going on. You may need an appointment, you may not, but we could usually at least point you in the right direction.
Okay, so what happens with the heirs if maybe you left the house to your daughter and your daughter was married and now she got divorced, and what goes on there? How do you figure all that out?
Yes. So one of the things that we focus on at our office, which is a differentiator, makes us a little different from other attorneys, is that we try to protect the assets for the next generation even after the assets are inherited. So what typically happens with a typical will or a trust is, mom and dad, they pass away, whomever it is, it goes to the beneficiary, and the money, the asset goes right to that beneficiary's name individually. Now, if they're married and there's a check written out to their name, if that check is deposited into a joint bank account with a spouse, guess what? If there's a divorce, even a day later, a week later, half of that inheritance could be lost. So it's very common that as soon as someone inherits assets, that if they are married, whether it's a happy marriage or not, that those assets get mixed together one way or another with their spouse's money. And as a result, there's a little bit of risk if they have a divorce or if they pass away, half or more of those assets could go to the spouse. Okay. So, and we love the spouses, but most of my clients feel that push comes to shove, if there's a divorce, they don't really want, they don't want the daughter-in-law walking off with half of the inheritance or the son-in-law. They would rather it be with their child, where their heir, their beneficiary, not the spouse if there's a divorce. Also, most of my clients want to specify if their beneficiary dies, they usually say, I want it to go to that beneficiary's children, from my son or daughter to my grandchildren, or to my niece and then to her kids. So with a trust, we can structure that better, because if the will or trust just leaves it to their name, we don't have that protection for the inheritance. We can't necessarily keep it in the bloodline from one generation to the next. Whereas if the trust creates an inheritance trust, so let's say we have two beneficiaries and the trust splits 50-50, well, half of the money goes to the inheritance trust for one beneficiary, where they might be the manager of their own trust. They could take out as much as they want. But at the bank, it sits there in the Janie Doe trust with let's say, Janie Doe as the trustee, but it's her inheritance trust. Now, the reason we do that, even though the beneficiary might have access to it, is that if there's a divorce, the money that's in their separate trust, their separate inheritance trust, is not mixed together. It doesn't have to be split 50-50. Or if the beneficiary dies, their inheritance trust share stipulates where that asset goes at the time of the death. So they can stipulate, the client can stipulate, from my child to my grandchild, from this person to that other person. So proper trust planning provides inheritance protection for the beneficiaries and helps to keep it in the bloodline.
I have another question. What's the difference between someone doing, let's say, a special needs trust, and is there an age limit for doing that special needs trust, as opposed to, doing a regular trust and then setting up maybe care within that trust for the person?
Yeah. So I would say there's like three different general types of trusts we could talk about. And in general, trusts are either revocable or irrevocable, right? So revocable versus irrevocable. Now, revocable trust is typically for someone who wants to avoid the court process when they die, protect it for their children, but still maintain full and total control, where they can take the money out anytime they want on their own. But that revocable trust, where they can revoke it, does not provide asset protection. If they go to the nursing home or they need a home health aid, Medicaid would say, you have a revocable trust. Hey, pal, revoke it. Take the money out. Spend the money on your care and then come back to us. So the revocable is not often used for asset protection, but it's more about tax planning and probate avoidance and inheritance protection. Now, for asset protection, we use an irrevocable trust when it's the client's own money and they may need Medicaid in the future. So if a client says, hey, I'm getting older, or I need a home health aid now, I'm over 65, and I want to get access to these benefits for long-term care, we typically are going to use an irrevocable trust when it's their own money. Now, sometimes, though, we use what's called a special needs trust. So a special needs trust is where a trust is for the benefit of someone, but they can't have the money in their name because they're receiving some benefits because of their disability or special needs. So a special needs trust would usually be set up, let's say there's a beneficiary who's already receiving Medicaid, who has a disability, who's getting SSI, someone in the family who really can't have access to the assets, they can't manage it on their own, and they're receiving these benefits. We would distribute the assets to that special needs trust, or really a supplemental needs trust, where the money in the trust is used to help them, but doesn't take away their benefits. It supplements, it doesn't supplant their benefits. So that's a supplemental needs trust. Now, usually if someone is older and they might need Medicaid for a home attendant or nursing home, they won't do a special needs trust for themselves, right? They might do that irrevocable trust, get it out of their name. But a special needs trust is going to say, hey, this other person, I want to leave them an inheritance and I want them to keep their benefits. Now, the one other instance where we do a special needs trust is, let's say someone receives money in their own name through a lawsuit, or they're a minor, and then we actually have the court through what's called a first party special needs trust. So again, special needs trust is usually where someone already has this medical or issue, physical issue leading to the disability. They're getting SSI, other benefits. We still want to leave them money, but we do it the right way through a special needs trust, versus irrevocable asset protection trust, when you're okay now, but you might need benefits in the future, or you've reached a certain age and need those benefits. I know that's a little bit of a long way around it, but it's a little complicated.
That's okay. It's good to know and hear it all, because it's very confusing. You know that I go to a lot of these different seminars that all your different attorneys put on, and we get different things from each attorney, and we hear it over and over because I'm in the business where people are giving me these kinds of documents. But when you're, the lay person not knowing and just trying to figure it all out, and like you said, being on the supermarket line and hearing the talk, and then you don't understand. So I'm glad you're really going through it for us.
Mm-hmm.
Now, what if a person has, let's say, been incarcerated, or maybe they have a bankruptcy, foreclosure, but you didn't know this stuff ahead of time? So you're going along, you make this trust, everything looks like it's fine. You don't know. People don't always tell you what's going on. Yeah. So is there some way after the fact that can be helped in some way?
Yeah, so that's a great question. So it depends on the trust. And this is where, again, we focus our trust on providing that ongoing asset protection for the beneficiaries, even after the trustor has passed away. And part of that is to build into the document these emergency holdback provisions that say, yes, so-and-so is the beneficiary, but if there's any of these issues going on, we're not going to put the money under their name. We're going to hold it back in the trust. So, and some of those issues might be a sudden disability, or a bankruptcy, or a lawsuit, or incarceration, or a serious drug or alcohol problem, or either significant undue influence or duress, where someone is influencing them and might manipulate them and go after their inheritance. The trustee can hold it back longer. So we have these emergency provisions in all of our trusts, and they've come in handy on multiple occasions, like you said, because if it's a plain basic will or a basic trust, and it says your money goes to your son and you pass away, if he's in the middle of a bankruptcy at that point, that money would go to the bankruptcy court, okay? If there's no mechanism in the trust to say, yes, it goes to your son, but if this is happening, we hold it back. Now, if it has that emergency mechanism, then the money will be safe. If it doesn't have the mechanism, then the bankruptcy court can take it. So again, in these things, we don't know in advance. So it's about doing the proper planning in advance, just in case. And sometimes I tell my clients, it's like I have like the worst case scenario hat on. And, I hate to think so cynically and think about, what the negative things that could happen. But in general, once you confront that worst case scenario, you look your fear in the eye, well, you buckle up, right? You protect yourself, you put some insurance in place, you put some backups in place. Now you've addressed it and you can move on. Because honestly, as we both talked about in the past, and we know from many clients we've worked on together, and that is that many of the decisions are emotional and they take a toll on a family when they need to put things in order. And it's difficult to sit down and say, let me go through everything that I own. Let me figure out how should things play out when I close my eyes. Who do I want to get what? Who should be in charge? It's very important, every individual take the time to do that. I know it's stressful sometimes, it's emotional, but do it, put it on paper, sit down with a counselor. You'll feel better after the fact. And most importantly, when you're gone, you won't leave a mess behind.
Is there anything that could be done if you're leaving money to someone and you feel like they might not be able to manage it properly?
Yes. So that's traditionally trusts have always played this role where they might say, hey, this money is going to be held in trust for this beneficiary, managed by this other person. Now, we can have a bank or a trust company manage the money if there's a very large amount of money, but even it might be an aunt or an uncle or a parent or a family friend who's taking care of the money for the beneficiary until they reach a certain age or until something happens, or just indefinitely until that trustee feels, well, now this person, has the wherewithal to manage it. So we don't, some of my clients put rules in the trust to say, I want, the aunt or uncle to manage it and distribute X amount per month, or give the beneficiary whatever they need to pay for these types of expenses or help them buy a house or go to school. But I don't want them to go buy a new Cadillac. I don't want them to go, to Atlantic City for the trip of a lifetime with 10 friends. That's not the reason I worked all those years. So, we can build those controls into place. And then, like we said, have the emergency measures on top of that so that, all along we know the money's going to be protected. And this is very important if someone wants to leave money, let's say down a generation, not to their, maybe not to the kids, but to the grandkids, or to the great nieces and nephews, or to the neighbors' grandkids and kids who are a lot younger. We don't want someone who's 18 or 19 getting a big inheritance all on their own, because majority of the time it's not going to wind up well. I mean, it's going to be fun for a short amount of time, but that money might be wasted, it might be mismanaged. So especially if someone's younger, or if we know that they have some economic issues or pressures, we want to have that other trustee involved to help them.
Great. Before we end, and we still have a couple more questions, I would just want to say to everyone who's viewing this, if you like this, you could support us by hitting the subscribe button if you're on YouTube, or if you saw this on my Facebook or LinkedIn page, become members of our either the LinkedIn PESID group or the Facebook PESID group, and that's how you'll find out about our future events. And so, Anthony, I saw something new and I thought was very interesting and good the other day, and I don't know, I would think maybe you've seen it. It's about checking accounts and people putting their names on the checking account with the senior. Are there any new laws in the works about that?
Well, there's been a lot of fraud going on, obviously, with those checking accounts. And I think that every bank is looking at it differently. But there are new laws coming out to protect folks from identity theft and things like that on a regular basis. I think the biggest thing that we work with our clients is consolidation. So one of the issues is that if someone has 5 different bank accounts or 10 different bank accounts at all different places, it's just much more difficult for them to keep track of that, and to notice something that's happening. Whereas if things are consolidated, then it's easier to do that regular review to make sure that everything is in order. Now, when it comes to adding someone's name to your account, we usually would say that, on a savings account, many times instead of making it joint, you could keep it in your name, but make sure there's a beneficiary. Whereas on a checking account where you can't always list a beneficiary, that might be the account where it makes more sense to have that joint. But at the same time, if it's a joint checking account, we might not keep as much money in there, maybe just more for, day-to-day operational expenses, and then keep the bulk of the funds in the savings account that's not joint but has a beneficiary.
Okay.
Mhm.
And what if someone has a power of attorney and they don't like the way things are being handled by the person that they gave this power to? I mean, what do they do?
Well, it's important to act carefully under those circumstances. So, the best way to revoke a power of attorney, really, there's a revocation document that needs to be delivered to your agent. So, first off, if someone has power of attorney authority for you and you don't want them to have it, you need to notify that person to say, hey, I'm firing you as the POA, as your power of attorney. And until they're notified, even if you sign a document, but they don't know about it, they could still keep transacting business. The second thing after you notify the agent is to notify any bank or institution where you have accounts. So it's not just that you give the person the new document to say you're no longer my power of attorney, don't do this anymore, but you also tell all the banks, hey, I revoked my old power of attorney, do not honor the old one. And you put the bank on notice and the old agent, okay? But it is a little more deal. And that's why we want to be really careful about who we choose as power of attorney. And then on the power of attorney document, we can select precisely how much authority to grant, especially in the realm of, can the person make gifts to themselves? Can they take money out of that individual's name, put it in their own name as the agent? So attorneys are very careful about drafting those specific provisions to the power of attorney document as to how much money someone can take out of someone's name. And that's where if someone just downloads a form off the internet with a power of attorney specifically, it's very risky. It might not have the right power. It might have too much power. Even though it seems like it's a simple document, it's really not. It's best to work with a lawyer when you're doing a power of attorney document.
Right. Now, I know we spoke a little bit about the cost of being in a nursing home. However, assisted living could be quite expensive as well,
Right.
or even home care for that matter. So, if they were dealing with home care, I know in New York, I think it's about $35 an hour. And if someone needed, 8 hours, that's a
Mhm.
little under $300 a day for 8 hours of coverage.
Yeah.
So, 10 grand a month. Now, I
Right.
understand also that when people go sometimes to home care companies, they might only get 4 hours or 6 hours of home care coverage through Medicaid. Is there a better method for dealing with that, especially if it's like, an immediate situation, like they didn't know they were getting sick or not well, but all of a sudden they had a stroke?
Yeah.
Um,
So
so,
I think, we always approach long-term care as being a combination of public and private pay for most clients, which means that even if you have Medicaid, in many cases, we're going to have to use your own resources to supplement that coverage. So if Medicaid is paying X, but you really need Y, well, we need to find that money one way or another to pay the difference out of pocket. And Medicaid is not necessarily going to be the first resort, not your primary plan. Many of my clients would prefer to go to the assisted living, even though it's 6,000, 8,000 a month or more. They have ping pong, right? They go on trips. They do, bingo. I for one, that's my goal, to retire to a nice assisted living, but or start at the independent living, end of things. But so many times we are using those assets, and that's a critical piece of dealing with a trust plan. Is we want to make sure, as we need this money that's in the trust, how do we take it out and use it on mom's behalf? And let's make sure there's an understanding amongst all parties that the number one priority is to make sure that this individual gets the best possible care. Protecting the assets, getting the benefits for, that's the secondary priority. Getting them the best possible care, whatever it takes, is number one.
right. One of the biggest mistakes that I've seen folks make is that they go and they apply for Medicaid either directly through Human Resources Association or they go through a home care agency. And many times the home care agency is just happy that they're going to be able to provide these hours of service. Is that, maybe not the right way to go about it? Should they really be calling an attorney first? Because many times, like I've seen people go to a home care company, they get approved for Medicaid, and they were making too much money, and they just give up all their money. And what could they have done about that, Anthony? I know you know the answers.
Yeah. So, I mean, we have pooled income trusts, we have irrevocable trusts. The key is that, you need to go to someone who is as objective and disinterested as possible. And when someone is selling you something, sometimes they have an interest in that thing, obviously. So you have to be careful, do your own research, do some due diligence, meet with a few different people. And hopefully, if you're working with an elder law attorney, attorneys are held to a pretty high standard ethically. We have what's called a fiduciary responsibility. We have to advise our clients as to what's in your best interest. So unlike a home care agency that can say, oh, you have no choice, but just give us all your extra income, a lawyer might say, no, you have this other choice, this pooled income trust. Even with $4,000 or $5,000 a month of income, you're still Medicaid eligible. Whereas the home care agency might say, too much income, can't get Medicaid, pay us privately for forever. And there are many people who just pay privately. They take the word of a non-professional. Not to say that they're always being taken advantage of. You want to consult with that professional because there's a lot at stake.
Well, the professional has the knowledge, right, Anthony?
That's right.
So thank you so much for being here today, Anthony. What I want to say to all you viewers is make sure that you hire someone who really understands the particular area that you need help in. Make sure that you're going to an estate planning or elder law attorney if you're, trying to set up wills and trusts. Like I said, there are plenty of good real estate attorneys out there. Can they write those things up? Yes, they can. But if they're not seasoned and it's not their area of concentration, then they may not know some of the specific things that they could be using and putting into those documents. Not every one of those documents is the same. There's so many different trusts out there. Mm-hmm. And even if you did do an irrevocable trust, many times you can still do things like a reverse mortgage. So just keep that in mind. If that's something you think you'd need to tap into, then you should certainly talk to the attorney ahead of time, because there's verbiage that they can put in there to hopefully influence the right decision, especially if you don't have capacity at the time to speak for yourself. Mm-hmm. And so thank you so much. Again, don't forget to subscribe to YouTube or join our Facebook group or our LinkedIn group. And we're also able to be found at PESID.com. So that's PESID. And if you can't read the small print on our little logo thing there, PESID stands for People Empowering Seniors Independence and Dignity.
Mm-hmm. All right.
All right. Thanks, Anthony.
Have a great day.
You too.